Very much, Madam Chairwoman, Ranking Member, for this opportunity to testify. My name is Carole Goldberg, and I've been researching and writing about a federal law known as Public Law 280 for nearly 50 years, in addition to other aspects of federal Indian law. And I can say with quite emphasis that Castro-Huerta got the relevant law entirely wrong. I'm going to focus my testimony on Public Law 280 because Castro-Huerta actually made a mess and a mockery of that statute. That statute should have precluded state jurisdiction, even if the Federal Indian Country Crimes Act, Section 1152 of the Federal Criminal Code, did not. Now, why should Public Law 280 have produced a different result in Castro-Huerta? Well, as you heard from the chairwoman of Tulalip, this law was enacted in 1953. It gave 6 states jurisdiction over crimes committed by or against Indians in Indian country. It also created a very specific mechanism for any other state to opt in to the same jurisdiction. And in 1968, that same opt-in mechanism was amended to require consent through a vote of the affected Indians. Oklahoma was neither one of the 6 states named in Public Law 280, nor has it ever invoked the mechanism of Public Law 280 to acquire jurisdiction over crimes committed by or against Indians. In 1971, in a case called Kennerly against the District Court, the United States Supreme Court required the state of Montana to use the mechanism of Public Law 280 to acquire jurisdiction, even though the affected tribe had made an agreement with the state to allow jurisdiction. Castro-Huerta assumes that if the tribe's interests aren't hurt by piling state jurisdiction on top of federal, state jurisdiction should be fine. But if that were true, the Kennerly decision would have come out the other way, because the tribe in that case had actually made an agreement. But instead, in Kennerly, the US Supreme Court insisted on strict compliance with Public Law 280 for a variety of reasons, including respect for Congress and for tribal sovereignty. I also explain in my written testimony why Castro-Huerta's attempt to explain away the inclusion of crimes by non-Indians against Indians in Public Law 280, their argument doesn't hold water. Basically, there is no evidence whatsoever in the legislative history of Public Law 280 that Congress ever doubted the preemptive effect of Section 1152, which Professor Berger has already explained. Congress believed that further legislation was necessary to allow state jurisdiction over crimes committed by non-Indians against Indians, and Public Law 280, with its mechanism, was that law. Castro-Huerta also reflects a misguided policy choice regarding Indian country criminal justice. My research, empirical research on Public Law 280 shows that under that statute, where state jurisdiction does apply, it has produced biased treatment against Indian victims and witnesses in state courts, as well as biased treatment favoring non-Indian perpetrators in state courts. The unanimous, bipartisan 2013 report of the Indian Law and Order Commission, on which I was privileged to serve, produced policy recommendations pointing in the exact opposite direction from the policy choices implicit in Castro-Huerta. We recommended moving criminal justice authority closer to Native nations and away from both federal and state governments. This was unanimous and bipartisan, Republican as well as Democratic appointees. And I want to stress, as have others, that tribes in Oklahoma are not the only ones affected by Castro-Huerta. Dozens of other states have either failed to opt into Public Law 280 or, as with Tulalip, their previously imposed Public Law 280 jurisdiction has been retroceded or returned to the federal government. Castro-Huerta would introduce state jurisdiction without the mechanism of Public Law 280, and that is just wrong. Not a single tribe has consented to state jurisdiction since 1968. But if any tribe today truly wants the state jurisdiction that Castro-Huerta spoke of, it can go ahead through the processes established by Public Law 280. The poor reasoning of that opinion also puts Native nations throughout the United States at risk in a variety of realms, as among others, the representative from Bay Mills Indian community elaborated. So thank you very much for this opportunity to testify. I look forward to answering any questions you may have.
Thank you, Professor and Associate Justice Goldberg. The chair will now recognize Honorable Matthew J. Ballard, who is the District Attorney for Oklahoma's District 12. You are now recognized for 5 minutes.